indicating a criminal history score of A. Ms. Norris, is there any objection to the criminal history score?
No, Your Honor, that is as we expected.
All right, and Mr. Watts, any objection to the criminal history score?
No, Your Honor.
This is a presumptive prison case. There are no special rules that apply. I don't see any departure motions have been filed. Is that correct, counsel?
That's correct, Your Honor. The recommendations, the parties would recommend this run concurrent with his current time. I will tell the court his current out date is in 2045.
State would be recommending the mitigated box of the mitigated end of the box, which is 40 months in the Department of Corrections.
All right, Mr. Watts, your recommendations?
Your Honor, we join the recommendation of the state. We are in keeping with the plea agreement. We believe they are appropriate here.
All right, thank you, Mr. Watts. All right, the victim in this case, Ms. Hannon, do you wish to address the court?
Appropriate box. My client, in fact, after his Sedgwick County case is certain he will be an A on the grid at time of sentencing.
All right, so no contest plea to amended count 1, attempted blackmail, level 6 person felony?
Yes, sir.
All right, and are there any special recommendations that will be made at the time of sentencing regarding this plea?
Judge, as I said, the low end of the appropriate box, we're going to ask that this case run concurrent to his Sedgwick County case. I don't believe there's any legal reason why that cannot be done. He's already serving a significant prison time as a result of the Sedgwick County matter.
Ms. Norris, is that your understanding of will be recommended at the time of sentencing?
Yes, Your Honor, that is correct.
All right, so it's not your thought that he was being supervised on the other case at the time this one occurred? It's fairly old fact scenario.
And Your Honor, no, the Sedgwick County case in this case happened around the same time frame. And I don't believe that he was on supervision for, well, certainly not that case, but any other that I'm aware of.
All right, and Mr. White, you've heard the plea agreement that's been announced, is that correct?
Yes, Your Honor.
And you wish to enter a no contest plea to amended count 1, attempted blackmail, in exchange for a dismissal of counts 2 and 3?
Yes, Your Honor.
A level 6 felony carries a sentencing range of between 17 months and 46 months in prison. Do you understand that?
Yes, sir.
Keeping in mind the matters we have discussed, is it still your wish to plead no contest and accept conviction for this level 6 person felony?
Yes, Your Honor.
All right, Ms. Norris, could you please provide a factual basis?
Yes, Your Honor. On or about June 28th of 2021 in Andover, Butler County, Kansas, the defendant did attempt to gain basically contact, compel contact by Christy Lynn Hannon. They had been in a dating relationship prior to, and defendant did repeatedly message her and was threatening to disseminate videos and photographs of a sexual nature, and basically was threatening to send those to specific friends and family members if she did not make contact. And at that time, there was a PFA in effect limiting defendant's contact with Miss Hannon. Will that be sufficient for the court regarding count 1, attempted blackmail level 6 person felony?
I believe it does. Mr. Watts, any comment regarding the factual basis?
No, Your Honor.
Mr. White, the court finds that you are alert and intelligent, that you understand the nature of the charges and appreciate the consequences of pleading no contest. I further find that you understand the rights you're giving up by pleading no contest, and that the facts of the case are sufficient for a finding of guilt. I further find your decision to plead no contest has been freely and voluntarily given after having received the advice of counsel. I will therefore find you guilty of amended count 1, attempted blackmail, a level 6 person felony, Ms. Norris, is the state dismissing counts 2 and 3 at this time?
Yes, Your Honor, the state would move to dismiss at this point, the counts two and
I am going to order a pre-sentence investigation report. We need to schedule a sentencing hearing at least 8 weeks out.
Judge, March 23rd at 1:15.
All right, we'll set a sentencing date for March 23rd at 1:15. All right, Mr. White, do you have any questions?
No, sir. Merry Christmas.
All right, you as well. Good afternoon. All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled State of Kansas versus Joshua Aaron White. All right, we're scheduled today for a sentencing hearing.
the court know that the victim is present and does wish to address the court as part of the sentencing process.
Of last year, there was a plea of no contest to 1 count of attempted blackmail, a level 6 person felony. The court did order a PSI at that time. I have received the PSI indicating a criminal history score of A. Ms. Norris, is there any objection to the criminal history score?
No, Your Honor, that is as we expected.
All right, and Mr. Watts, any objection to the criminal history score?
No, Your Honor.
This is a presumptive prison case. There are no special rules that apply. I don't see any departure motions have been filed. Is that correct, counsel?
That's correct, Your Honor. The recommendations, the parties would recommend this run concurrent with his current time. I will tell the court his current out date is in 2045.
State would be recommending the mitigated box of the mitigated end of the box, which is 40 months in the Department of Corrections.
All right, Mr. Watts, your recommendations?
Your Honor, we join the recommendations of the state. We are in keeping with the plea agreement. We believe they're appropriate here.
All right, thank you, Mr. Watts. All right, the victim in this case, Ms. Hannon, do you wish to address the court?
So,
If you could
yeah, I would like
state
to
your
go.
name for the record, please.
Christy Hannon.
Okay, and you wish to make a statement?
Yeah, I have a victim impact statement I'd like to read.
All right, go ahead.
Okay. So, Your Honor, my name is Christy Hannon, and I am here today as the victim in this case. For more than a decade, my life was shaped by fear, control, manipulation, and abuse. What happened was not just moments in time. It was years of emotional trauma, stalking, intimidation, and blackmail that affected every part of my life. I lived in constant fear for my safety and for the safety of my children. I questioned my worth, my strength, and even my ability to survive. The abuse did not end when the relationship ended. The stalking, the threats, and attempts to control me continued stealing my peace, my sense of security, and years of my life that I can never get back. Because of this abuse, I have carried anxiety, trauma, and emotional scars that no one can see. I have had to rebuild my life piece by piece, learning how to feel safe again, how to trust again, and how to believe in my own voice again. I have lived with the lasting impact of choices that I did not make but was forced to endure. But today I'm not here only as just a victim. I'm here as a survivor. I have fought to protect my children. I fought to rebuild my life. I fought to become the woman I am today. I am strong, resilient, and determined that this abuse would not define the rest of my story. What I want the court to understand is that domestic violence, along with blackmail and stalking, is not just physical harm. It is power and control. It is a fear that follows you long after visible wounds are gone. It is years of healing from damage that should have never happened, and accountability matters, not just for me, but for every victim who's afraid to speak up. Your Honor, I ask the court to consider the seriousness of these actions and the lasting impact they have had on my life when determining sentencing. Blackmail against an abuse victim is especially cruel. It is another form of power and control that keeps a survivor trapped in fear and silence. It takes someone who is already wounded and threatens their safety, reputation, and stability in order to maintain dominance over them. The emotional damage of living under that kind of threat is profound and long-lasting. No survivor should ever have to live in fear of being manipulated or exposed simply for trying to escape their abuser. Because of the severity and lasting impact of these crimes, I respectfully ask the court to impose the highest sentence allowed by the law. This request is not made out of hatred or revenge, but out of the need for justice and accountability and protection, both for myself and for others who could be harmed in the future. I am sure that you have reviewed the defendant's PSI report, and you can see this is not just an isolated incident. The defendant has a long criminal history and up until recently was always given minimum accountability for his crimes by the criminal justice system. A strong sentence, a clear message that domestic violence, stalking, and blackmail will be taken seriously and will not be tolerated needs to happen. As a victim, when you listen to the plea and sentencing negotiations recommended by the DA and the defense counsel, it feels as if the victim doesn't matter when the recommendation is the lower end of the sentencing grid. Victims receive a lifelong emotional sentence that needs to be taken into consideration. And these are not private matters. They are crimes that change lives forever, and a minimum sentence on the sentencing grid is not appropriate. Therefore, again, I am requesting that you impose the highest sentence that you are allowed to by law. Thank you, Your Honor.
Thank you, Ms. Hannon. All right. Mr. White, is there anything that you would like to say before the court pronounces sentence?
Your Honor, I would love to just say that what I'm going through and the things that's happening to me through all this is, and she sits here and she gets to read this victim statement, and I'm sorry that she feels the way she does. We've been in a relationship for a long time, a long time. She's been in love with me since she was a child, 13-year-old child. We've been dating, having sex since that time. And she comes on here and acts like she said it herself, revenge. And this is exactly what she's already piled years on me. And we've been battling with these same cases since 2019. And she stacked them high. She went to Sedgwick County and read the same report. And they gave me the sentence because I went to trial to stand up for my rights because I'm an innocent person. I didn't do some of these things. Some of them I did. Some of these I did, but not the ones that carry the most weight. And I'm in here fighting myself. And now I have no jail credit for this case. And I understand that. It doesn't make it right, but I've been battling this same case, this same stuff since 2019. She waits until I get charged in Sedgwick County and then stacks these on top of me too. If I beat these, I'm going to do 4 years from today. If I beat these other charges in Sedgwick County, I still got to do 40 months. 40 months whenever I beat the Sedgwick County stuff, because I have a lot of things for my favor because she's not a victim. And I hate saying that because she gets up here and she reads this letter. That letter, she almost didn't even look down. She had it memorized. She's good at it. She's been great at it. But not everything that I've done is true. I didn't do all these things. This stuff here, this is basically, if you go read my Sedgwick County case and this Butler County case, there's a lot of similarities to the same thing. It's the same criminal case. It's the same crimes. But I'm sitting here in Lansing Correctional Facility for something I didn't do, because if I wouldn't have got charged with that big thing, taking it to trial, fighting for my life like an innocent man should, I wouldn't be here. I hate where I'm at. I'm physically just, I hate it. This place is awful. I don't recommend it for no one at all. She's done this to me out of revenge, out of being sad, from me being with another woman. And this other woman's in this court today. She's watching, thank God. But I asked for some kind of leniency, some kind of time. And they're going to start my time today, even though I've been battling this for years, since 2019, and I don't want to take what she says and act like I don't understand who she is, because I know her very well and she knows me very well. I'm sorry that she feels so much hatred towards me and revenge to just get here and talk like this. And she's very believable. You know, it's sad. I'm here, she's there. And I never in a million years would think I would be somewhere where I'm at for something I didn't do, but here I am. And now I'm getting piled on again. I guess you asked me if I had one thing to say. I would love to say, I apologize for all the bad things that me and her went through, for her to feel so much hatred and want revenge and want these things from me, and say that she's this horrible victim and she had to keep her kids. I raised her children. Her children grew up to be good kids because of me. Her kids were awful when I came around, and I'm not want to talk about the children. But the way that she was as a parent, she would be awful, awful. I mean, she smoked cigarettes in her house with her children, and I didn't allow that around my kids when they came over. She was just, and that's minimal. That's minimal. Picking. We can do this all day. But here she is filing charges on me and they're sticking. But I'd love to apologize to the courts for this all going through this. And it's on, the time's on me, not her. This has nothing to do with her. She's had to write this victim statement and type it up. She had it memorized. She didn't have to look down. I know who she is. I pray to God every day that I get out of this situation so I can move on with my life, because I'm the one in prison. I'm the one that has to do the time. And and it's for something I didn't do. It's phone harassment or messaging her, talking to her, or something like that. Blackmail. What was the blackmail? I got all the charges, but did you read the facts of these things? And it's like, how, but I guess maybe I shouldn't talk because I have a lot of built up time to think here. You know what I mean? It's all I got here. It's all I can do is think. And I look around, I wake up and I live in a bathroom with another man. And I know that's not your guys' issues, but she's piled it on enough for me. And I don't feel 40 months is fair. I really don't. But then again, if you don't like the plea and you give me more, please don't do that. But I would love some time credit. And I know I'm not probably going to get that. That's what I'm asking is maybe a little time, because I've been in Sedgwick County Jail from 2021 until now, battling the same stuff. I mean, it's basically just changed 20 miles from Sedgwick County on Main to Butler County on Main, or wherever you guys are at. But I'm sorry. Thank you. And that's all I have.
All right, thank you, Mr. White. All right, Mr. White, for the primary offense of attempted blackmail, a level 6 person felony with your criminal history score of A, I'm going to sentence you to the aggravated term of 46 months with the Department of Corrections. I understand the plea agreement anticipated 40 months, but I don't think this situation warrants a mitigated sentence. In fact, warrants the aggravated sentence. So that's what the court is imposing. You are eligible for 15% good time credit and are subject to 24 months post-release supervision. There is no jail credit attributed to this case, so none will be awarded. I am going to order you pay the court costs in the case. I'm not sure if this is an expungible offense, but at the appropriate time, if you wish to consider expungement, you may look into that. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford an attorney to do an appeal, one will be appointed for you.
This defendant walked into court acting like the law didn't apply to him, throwing around random legal phrases and claiming the court had no jurisdiction. But the judge shut it down immediately, making it clear that the Uniform Commercial Code has absolutely nothing to do with criminal traffic charges. Even after refusing legal help, objecting to nearly everything, and insisting he didn't consent to the proceedings, the court calmly moved forward with the arraignment. Instead of arguing back emotionally, the judge stayed patient and professional while the defendant continued trying sovereign citizen tactics that clearly weren't working. In the end, the court entered a not guilty plea on his behalf, scheduled the next hearing, and reminded him that refusing to recognize